This video is all about motion in limine. What is a motion in limine? Why do I need a motion in limine? And what do I do if somebody violates a motion in limine? Yes, all these questions will be answered in this video because I plan on giving you an inside look to one of my lessons from Trial Academy, which is an online course designed to give you the skills necessary to kill it in the courtroom. And this lesson begins in 10, 9, in talking about the pretrial conference, we've covered a lot. Specifically, we've talked about witness lists, we've talked about exhibit lists, deposition designations, uncontested facts, stipulations. It's been a lot, but we have yet to talk about the motion in limine. This is important, so it deserves its own specific lesson. Now, with a motion in limine, you need to first determine when it needs to be on file. There may be a deadline, so be sure to look with your local court in your jurisdiction and determine, does it need to be filed, I don't know, X amount of days before the pretrial conference, or does it simply need to be filed X amount of days before the trial? Now, you also need to note that you may have to argue the motion in limine at the pretrial conference, or you may need to argue it the first day, essentially the morning of your first trial, or the first day of your first trial, excuse me. Now, the question to first answer is, what is a motion in limine? A motion in limine is a way to prevent inadmissible evidence from having an unfairly prejudicial impact on the jury. Let's make this definition a little bit clearer by way of example. Let's say you're representing a plaintiff and your plaintiff is a drug dealer, and that information or that fact came out during a deposition. At some point, you call your plaintiff up there on the stand, you conduct your direct examination, and then opposing counsel during their cross-examination asks this question. You're a drug dealer, correct? Now, that is not a good fact that you want to come out because the jury is immediately going to start discrediting the testimony coming from your particular plaintiff. That's not good. That's not what you want. So this gets to the point of a motion in limine. If the very fact that your client is a drug dealer has no bearing on the case, is not relevant whatsoever, then you're going to want to stand up and make your objection to the judge. If the judge sustains your objection and agrees with you, then the issue you have is that the jury just heard this fact. So you can try and remedy this potential unfairly prejudicial fact by asking the judge to instruct the jury to disregard that fact and disregard that question. But the issue there is, are they really going to put it out of their mind that your client is a drug dealer? You know how the saying goes, you can't unring the bell. So the problem really is the fact that the question was asked in the first place. That's when the motion in limine comes into play. So to circle back to prior lessons, if we look at the working document that we made that lists all the bad facts for our case, what we want to do with our motion in limine is figure out which of those bad facts will end up, just by the mentioning of them, biasing the jury. If you can take those facts, you're going to want to put them in your motion in limine and you're going to want to address them specifically. I apologize for the pause of this lesson, but if you're still watching, I hope that means you're enjoying this particular lesson. And if that's the case, be sure to hit that like button below and don't forget to subscribe. Okay, back to the lesson. In doing so, whenever you identify a bad fact in your motion in limine, be sure to also, for each specific one, list your legal basis and explain why. Also keep in mind that as you go through the rules of evidence and you try and find a reason why this bad fact is inadmissible, you always want to have the ultimate fallback, which is Rule 403. In fact, you probably want to have Rule 403 objections for every single bad fact because that's the ultimate catch-all. Now, we will talk about Rule 403 and other objections in other lessons, but if you want to go ahead and get your Rule 403 fix, be sure to check out my YouTube video that talks about the arguments that need to be made whenever you make the Rule 403 objection. Also keep in mind, and this is important because a lot of people I think get this issue confused, if the judge ends up granting a motion in limine on a specific request, that does not mean that the particular piece of evidence is inadmissible. The judge simply wants you to approach and ask for the jury to be excused so the admissibility can be argued outside the presence of the jury. So what ends up happening is that if you end up winning the motion in limine, opposing counsel at some point, if they want to bring that fact up in front of the jury, they're first going to have to stand up, ask the court if they can approach. Both sides, both counsel will end up going up to the judge, and the opposing counsel will simply say, Your Honor, at this point in time, I'm going to want to get into matters that were mentioned during the motion in limine and were ultimately granted. So I ask that the jury be excused so we can argue the admissibility to this particular fact or this particular piece of evidence. And it's at this point that the judge will look to the jury, ask for them to be excused, they'll leave, and then outside the presence of the jury, both lawyers will make their arguments and the judge will determine whether or not this fact or this piece of evidence is admissible. Keep in mind that the judge would probably prefer to make rulings on the admissibility of evidence at this point in time and not before trial whenever the motion in limine is argued. That's because sometimes the other side can open up the door to a particular piece of evidence or a particular argument, or sometimes the judge just wants to see the context of this particular piece of evidence or the arguments being brought, and that way the judge can better determine relevancy and whether or not that particular piece of evidence or the argument survives Rule 403. Let's go ahead and circle back to the beginning stages of a motion in limine. If your motion in limine was granted in whole or in part, then whatever was granted, it needs to be understood to opposing counsel that opposing counsel cannot make those arguments, and hopefully opposing counsel does understand that, and opposing counsel needs to instruct their witnesses not to talk about those particular facts or pieces of evidence, and to simply not let it slip out of their mouths. That is something that's going to be very, very important. Hopefully opposing counsel understands that and can make those instructions to their own witnesses, but you want to make sure it's very, very clear to them, and you want to make those instructions potentially clear on the record. That way, if something does slip out, you know that opposing counsel was well aware of the instruction by the court to approach the bench and have the judge make the determination on the admissibility of the particular piece of unfairly prejudicial evidence outside the presence of the jury. Keep in mind, this is a two-way street, so if the other side ends up having issues granted in their motion in limine, be sure not to mention those, and also instruct your witnesses not to let it slip whenever they're testifying. Now, in the event if the other side ends up violating the motion in limine, this is a big deal. You're gonna be kind of at a crossroads, and you're gonna have to make a judgment call on how to handle this situation. On one hand, you can be super fired up and charged up, and you can stand up and throw the chair back and get real angry and explain to the judge in open court in front of the jury what just happened. On the other hand, you can be calm, cool, and collected about it. I typically lean in favor of being calm, cool, and collected, and here's why. If a bad fact comes out in violation of a motion in limine, and if you stand up and you're fired up, you're gonna do two things. One, you're gonna wake the jury up, and two, you're basically gonna be telling the jury indirectly by your own actions that this bad fact is true, and that's why you're being so defensive. On the other hand, if you take a much more chill approach, you may be able to alleviate that concern by simply cutting off the testimony or cutting off the question by standing up immediately, quickly, but really calmly, and asking to approach the bench. And then asking, as soon as you do approach the bench, for the jury to be excused. That tells the jury, okay, something just happened, but I wasn't really paying attention to what it was. I didn't really have time to really play catch up in that moment. By the time it happened, they were already being asked to be excused. Well, if you're calm about it, they may also think, yeah, this is maybe a false statement, or maybe this is true. I don't know. And then whenever they come back, if you end up winning on that particular issue, if the judge gives them that instruction, they may say, okay, clearly this wasn't an actual true fact, or clearly this isn't an issue because the judge just instructed me not to consider it. At the same time, it's hard to unring that bell. So if the other side does violate the motion in limine, you're gonna have to make another judgment call of whether or not you wanna ask for a mistrial. Now, when it comes to a mistrial, this is kind of your last resort, because if you're killing it in the courtroom, if you have a great jury, then maybe you just wanna continue on, because with the mistrial, you're gonna have to start over. You're gonna have to get another trial setting, you're gonna have to go through these hoops again, and you're gonna have to hope that you get either a good jury or a better jury. Now, there's always the situation where maybe you just have a bad jury in the next case. And that's a risk you're gonna have to take if you end up asking for the mistrial and it ends up getting granted. But keep in mind, just because you're asking for the mistrial, the judge may not grant that particular mistrial. And then you're gonna also have to make the judgment call of, okay, do I wanna ask for the mistrial and preserve this objection on the record? If you don't ask for the mistrial, you may end up waiving whether or not you should have been granted the mistrial if you end up losing. This really complicates things, and the judge should not be happy with opposing counsel for violating the motion in limine, but you're gonna have to make judgment calls all around, and you may just wanna ask for a quick recess so you can talk to your client, explain the scenario to your particular client, and figure out what your client is wanting to do. Putting aside the most extreme situation, let's go ahead and take a few seconds to go back to the beginning stages of a motion in limine to talk about two things. First, after both sides have exchanged their motions in limine before the hearing, It's worth seeing what y'all can agree on when it comes to agreeing to approach on certain matters. Keep in mind, by agreeing to the other side's motion in limine in whole or in part, you're not saying that those particular pieces of evidence are inadmissible. Instead, you're just agreeing to approach the bench and to ultimately argue those facts or those pieces of evidence outside the presence of the jury. Now, the second thing I do want to touch on is make sure that your motion in limine is trim and as short as possible. You don't want to go to the judge with, 200 bad facts and the judge get the impression that your client doesn't have a good case. Now, if you have any questions about this, be sure to let me know in the comments below. And I also plan on having a boilerplate motion in limine to help you out. I'll see you on the next lesson.